and his mood is admirably expressed in the autograph experimental draft of a dispatch suggesting this course. "The President is unwilling to believe," he wrote, "that Her Majesty's government will press for a categorical answer upon what appears to him to be only a partial record, in the making up of which he has been allowed no part. He is reluctant to volunteer his view of the case, with no assurance that Her Majesty's government will consent to hear him. Yet this much he directs me to say, that this government has intended no affront to the British flag or to the British nation, nor has it intended to force into discussion an embarrassing question, all which is evident by the fact hereby asserted, that the act complained of was done by an officer without orders from, or expectation of, the government. But being done, it was no longer left to us to consider whether we might not, to avoid a controversy, waive an unimportant though strict right, because we too, as well as Great Britain, have a people justly jealous of their rights, and in whose presence our government could undo the act complained of only upon a fair showing that it was wrong, or at least very questionable. The United States government and people are still willing to make reparation upon such showing. Accordingly, I am instructed by the President to inquire whether Her Majesty's government will hear the United States upon the matter in question. The President desires, among other things, to bring into view and have considered the existing rebellion in the United States, the position Great Britain has assumed, including Her Majesty's proclamation in relation thereto, the relation the persons whose seizure is the subject of complaint bore to the United States, and the object of their voyage at the time they were seized, the knowledge which the master of the Trent had of their relation to the United States, and of the object of their voyage, at the time he received them on board for the voyage, the place of the seizure, and the precedents and respective positions assumed in analogous cases between Great Britain and the United States. Upon a submission containing the foregoing facts, with those set forth in the before-mentioned dispatch to your lordship, together with all other facts which either party may deem material, I am instructed to say the government of the United States will, if agreed to by Her Majesty's government, go to such friendly arbitration as is usual among nations, and will abide the award." The most practiced diplomatic pen in Europe could not have written a more dignified, courteous, or succinct presentation of the case, and yet, under the necessities of the movement, it was impossible to adopt this procedure. Upon full discussion, it was decided that war with Great Britain must be avoided, and Mr. Seward wrote a dispatch defending the course of Captain Wilkes up to the point where he permitted the Trent to proceed on her voyage. It was his further duty to have brought her before a prize court. Failing in this, he had left the capture incomplete under rules of international law, and the American government had thereby lost the right and the legal evidence to establish the contraband character of the vessel and the persons seized. Under the circumstances, the prisoners were therefore willingly released. Excited American feeling was grievously disappointed at the result, but American good sense readily accommodated itself both to the correctness of the law expounded by the Secretary of State and to the public policy that averted a great international danger, particularly as this decision forced Great Britain to depart from her own and to adopt the American traditions respecting this class of neutral rights. It has already been told how Captain George B. McClellan was suddenly raised in rank at the very outset of the war, first to a major generalship